I'm here on behalf of the Texas Trial Lawyers Association in opposition to Senate Bill 1628. We've heard the description of the problem, a big hailstorm in Dalgo County, 30 to 40% claim rate. The response to that is to take away the rights of every policyholder in the state of Texas that isn't involved in any of the abuses this bill is aimed at. It's also based on a false premise. The mere fact that there's 40% lawsuits resulting doesn't tell you if that's because of extra bad behavior by the insurance companies, bad behavior by adjusters, bad behavior by plaintiffs. And no one has bothered to inquire into that before launching this missile to take out the rights of every policyholder in the state of Texas. One thing we know from publicly reported cases, some recently, by a very highly placed lawyer who has a very highly placed client, who also has a property damage claim in the Valley, there has been evidence of overt racism by the insurance adjusters and the insurance companies in denying those claims. And yet, we assume that the mere fact there are more claims means it's all these bad plaintiffs' lawyers and all these bad plaintiffs. Added to that, this is not a remedy for any of those problems. This is the Christmas list of the insurance industry on what they wanted for more than 40 years that no legislature before now has ever seen fit to do. The law we have in place right now extends back 40 plus years to 1973 when it was passed. It was trimmed back, adjusted, strengthened in 1995, a tort reform session, to incorporate the careful balance it currently has. The current system weeds out the good claims from the bad claims. The current system gives insurance companies defenses, counterclaims, ability to push back, and at the same time preserves the ability of claimants to go forward. You've already discussed at some length. This immunizes adjusters, no matter how bad. It creates a unique special interest group in the state of Texas that is immune from any accountability, unprecedented. If a truck driver runs over me, I get to sue him for being a bad truck driver, and I get to sue his company. If an adjuster runs over me, I have no recourse as to him. He's immune. The current language also would immunize the insurance company. The current language, and this goes to Lee Gross's point, by saying you cannot recover policy benefits and by saying you cannot recover any other damages caused by the claim denial, this bill as it's currently written takes away any recovery for someone like Lee Gross who has a misrepresentation. For people who have a wrongful denial case, it limits them to breach of contract, which has never been sufficient to deter bad conduct by an insurance company. If it was, we wouldn't be needing these statutes, but we do. The only thing in this that comes close to a solution are the provisions that do address some bad practices by public adjusters. And by the way, you don't get to them until Section 13 of the bill. The rest of it is nothing but a giveaway of cheats and advantages to the insurance industry. And respectfully, it does take away the 18% penalty. Right now, it's a bunch of deadlines.
Go ahead, finish.
What this bill does, it does three things. One, an insurance company only has to be able to count to 15 to know when to acknowledge a claim. An insurance company only has to be able to count to 60 to know when to pay a claim. The statute's very clear. This takes the focus away by exempting them from any liability for violating deadlines unless they did it knowingly. It changes the focus from meeting deadlines to making up excuses. The second way that it reduces the penalty, an insurance company can invoke appraisal no matter how long the claim has been disputed or in litigation, and that creates a safe harbor, no matter how unfair or how late, or even if they reject the offer after the umpire decides what should be paid. That's an exemption. It guts the 18% penalty. The third way it guts the 18% penalty is by an insurance company can make a partial payment, and that cuts off the penalty on that part. That doesn't work when you need the whole payment to replace the whole roof. It encourages them to lowball it because to the extent they lowball it, even if it's not enough to fix the roof, they avoid any penalties. This is a bad bill as written, and it doesn't accomplish, respectfully, Senator Taylor, any of the goals, the laudable goals that you set out to. So we look forward to working with you if possible.
Yeah, and if I could, Mr. Kincaid, we've had this discussion, and you bring up the public adjusters. And what do you think the problem is with public adjusters?
I don't have any personal awareness. My experience is anecdotal, like many of us, but our philosophical view is we've always been in favor of opposing barratry by lawyers, opposing case running by lawyers, because the bad ones drive out the good ones. If insurance adjusters, roofers, or anyone else is out there able to generate a lawsuit, they should be required to do that by the same legitimate means that apply to lawyers, chiropractors, other groups. And there are some improvements in your bill that I think would address some of the reported abuses.
And frankly, and that gets back to the genesis of where this bill comes from. And so that's why I'm telling you, and we've had this discussion, I want to work with you guys. The issue is not legitimate claims like we've heard here today that weren't getting paid. The issue is people being solicited to file a suit, not knowing they even have damage or have already had damage and they were paid. So that's where, and I'm not saying all public adjusters, I'm saying there's a lot of good public adjusters. You're not saying that either.
No, sir.
There are a lot of really good public adjusters and a lot of good lawyers out there. There's some that are taking advantage of a situation and they're actually soliciting lawsuits. And that's really what this bill is about, is the solicitation of lawsuits to people who don't know they even have a major problem, or in this case, as I read off to you earlier in that claim, a made-up problem. You know, the roof had already been replaced. So that's where I want to work with you guys. We need to get something to fix this because it's not just one county. It's not just Hidalgo County. So we can talk about whether the insurance company went crazy in Hidalgo County, but why did they also go crazy in these other places at the same time? I mean, it doesn't make sense. We go from 1%, it's not claim rate, it's litigation rate on claims that were already filed.
It
So
could
you
be
go from
hydrophobia.
1%, which is going to happen. You're going to get crosswise with a company. That's going to happen. That's normal. And we can't fix that. There'll just be some time when people get crosswise for whatever reason. What I'm after is the mass litigations. They're not driven by consumers having massive problems, but being driven by some folks in the industry trying to gin up lawsuits and those types of things. That's really what this bill's about. So we keep it back on that. I'm not disagreeing with anybody here who's had a claim and had to sue. I think you had that right, and I'm trying to maintain that right. And if we've got something worded incorrectly, then we want to fix that. But we've got to stop the mass litigation that's driven not by people, but by lawyers and some public adjusters. And I'm saying the bad lawyers and the bad public adjusters, because there's a whole lot of good ones out there. So I just want to, if we kind of keep our focus on that, and we've got a lot of work to do on this bill, obviously. We didn't have a chance to get a lot of this stuff done before this hearing, and I apologize, we've been on finance and been otherwise occupied, but that's the point, I guess, refocus back on that issue. So.
Senator Ellis.
I guess I'm just more trying to sort through if the issue is trying to get at bad lawyers. If I can just draw the analogy. I mean, I think one of the witnesses made reference to a backlog if you ended up having to go into federal court because of so many criminal cases. Why don't we just give some of the criminals immunity? Then you wouldn't have a backlog.
Yeah.
I'm just serious. That's the logic that I'm getting. Mr. Chairman, if the issue is you're trying to get at barratry issues or running cases, well, it'll be a bill to go and deal with that. But when you go into the logic behind, most people get their adjusters from the insurance company, right?
Right.
I mean, they got a fairly cozy relationship. And I think with regard to church, you said you went through a couple of adjusters and then you decided to go get a public adjuster. Then they duked it out, and I wouldn't want to get in an argument with you when you're the secretary of the whatever it is at the church. That's, you know what I mean? They kind of figured that out even before you got the lawyer. They could have talked to me and figured that out. and so the way you're going to somehow cut down on bad adjusters is who are picked by the insurance company is give the adjusters immunity from liability. It's hard for me to follow that logic. So my question is, how do you get to, and then you're going to go and increase the liability, I guess, because you're going to write in the statute for the church folk, saying that they know, the public adjuster told them they needed a complete roof. And then they're going to sign something, maybe under the threat of criminal prosecution. And may the Lord be with you if you get in that category. I know how it works on that side. So what could be done in a separate bill? Why would you need this broad caption related to insurance claims? Why wouldn't we just go and relate it to the lawyers if we want to get to a barratry issue? Mark?
Well, really, the provisions in here that relate to public adjusters, I think, are all constructive, and it's sections 13 through 21. Senator Taylor and I even discussed there are some ways that anti-barratry laws as to lawyers go further and create a civil penalty. That might be worth exploring in this instance because the criminal and administrative enforcements typically haven't been enough. But there's a way to get at the bad adjusters, but I certainly agree with your logic, Senator Ellis. Immunizing them isn't the way. And by the way, on that point, if I might add one thing, right now, if I sue under Texas law, if the adjuster violates Texas law, the adjuster can be sued under Texas law in a Texas court. That's the way it's always been. If I make up a claim against the adjuster just to stay in Texas court, the insurance company's got the right now to take me to federal court and immediately, first 30 days of trial of the lawsuit, have a federal judge look at whether I have stated a valid claim or not. If I haven't, the insurance company gets treated just as if I had not sued the adjuster. They get to be in federal court. On the other hand, if a federal judge looks at this and says, you've stated a potentially viable claim, it goes back to state court. That strikes me as exactly the balance we're already looking for, is let's weed out the ones that are unmeritorious, they stay in federal court. That happens now. Let's send back the ones where they've got a legitimate claim like you've heard today, and that's the existing procedure. This bill, as it's currently written, just gives the insurance companies what they want.
So now, the reason I keep harping back to this adjuster bit and the engineers, it's just hard for me to understand the logic of how somehow that would cut down on bad adjusters. I will concede there are bad. There are some bad adjusters. I think that issue was really going to trying to keep people out of state court and force them into federal court. Here's my question. I meant to ask Mr. Badger, but you know, he's here pro bono. He's done enough. I just didn't want to bug him anymore. But I'm just curious to know if you know, or can you find out if any other state gives adjusters immunity from liability for the work that they do and get paid to do?
Senator, I'm not completely familiar with the law of all 50 states, but every state that I do know of, which is a few, does not immunize the wrongdoer who denies a claim unfairly.
And I have not taken the time to read my insurance forms, but I will concede, because it was said earlier by some witness, maybe Mr. Badger, that when I signed my insurance deal, I'm saying that I believe whatever I'm claiming is accurate and whatever. That's in there. Do you know if any state puts that in statute and with the threat of criminal prosecution?
No, I'm not aware of any state that does that.
So that is, I mean, the parts of this bill that you all work with, but when the caption is just that broad, look, if it's something that you all can all agree to, be good. I want to vote for it, but I would want to come back over here at some point. You know, Mr. Chairman, with all due respect, y'all got me down to
Senator
19
Taylor, you want
votes.
to address that?
Not privy to that, I was going to ask Mr. Kincaid another question.
Senator Ellis, you finished?
Well, would
I
you
wasn't trying to interrupt.
No, he was asked, can you answer that for me? Like, if, so I'm saying is, if
Well, the
something
panel
can be
can't
worked out,
answer
you
it.
got a very broad caption,
Well-
if I might. I just want to get some sense that if we agree to something,
I can tell you who my house sponsor is that we'll work with is Representative Chairman Smith. And he knows this a lot better than I do.
okay.
I don't think he's going to put a lot of detrimental stuff on this bill. We're trying to get at a specific problem. He's already sent me some other wording that we got last night. Obviously, weren't able to put into a substitute by today. But as far as opening the caption, I don't think there's any move towards a free-for-all on the floor to add a bunch of amendments on here. I think.
Well, it's important, obviously, because over here, we're down to 19 now. You got me? And then when it comes back, it's 16.
Well, let me tell you this.
Let's y'all change that too.
Yeah, my perspective, and I think
Before this is over with, we might have to.
Yeah, might go down 10.
well, my goal in this bill is not to go into a lot of other additional things. I have a specific role in mind. And to your question, going back to, once again, the immunity we keep bringing up for the independent adjusters working on behalf of an insurance company, which is what we're trying to get at. Are you familiar with independent adjusters being severed from the lawsuit with the insurance company and actually going after the independent adjuster and not the insurance company?
I have heard of cases where that has been part of it. You may be familiar, there's a famous State Farm case where the Texas Supreme Court held that State Farm could be liable because it repeatedly relied on Hague Engineering to give dummied up false reports and knew they were going to be dummied up and false. I imagine in the Hague Engineering cases, Hague Engineering had some direct responsibility. But at the end of a lawsuit, a consumer needs to get their roof built.
Right.
And whether it comes out of the pocket of the adjusting company's insurer or the insurance company doesn't matter. What does matter, though, is if you're going to modify behavior, you've got to hold people accountable.
Well, getting back to my point, and I'm not sure if you're here, Senator Ellis, when we talked about this, we've had independent adjusting firms being repeatedly sued to the tune of, $5,000 a pop for their deductible, and they're not really the source of what's going to pay that ultimate settlement. And they're just being included. So what we're trying to get is that, because the ultimate claim is going to be paid by the insurance company, whether it's with penalties and all the other, but it's not going to be paid by the independent adjuster firm who acted on behalf of whichever company they're working with. So that's what we're trying to get at. So you want to help with some wording on that?
Senator Ellis, you have something else?
It's just a guess on my part. I am a lawyer, but I don't practice in this space.
You want to talk?
But if the issue of liability, of giving immunity to the adjusters is to protect the adjusters who are really selected in many of these cases by the insurance company. We cannot control whatever federal rules are. And if that's the way I could get my claim into my hometown court, well, I'd want it to. I mean, how does that work, Mark? Maybe you can answer this. I mean, because I think that whole issue, you said it earlier, Senator, it wasn't something you drafted. I mean, other folks, it was not your intent. And look, and I've been there, you know what I mean, on these bills. But all of them that I have in there, I can't say I drafted them either. You got me? But it looks like somebody was really trying to get at this issue of which forum you would have. And both sides will argue which one is forum shopping. But now how's that decided? Is that because of the federal rules that if somebody cannot go at the insurance adjuster, they don't have the option of having it in state court? How does that work?
It goes back to the 13 colonies. They were creating a federal court system, and they were very suspicious of each other. And there was a fear that if a resident of Texas was suing a resident of New York, Texas wasn't a colony, but you get my point, that there might be local prejudice. And to try to deflect that, they gave the foreign entity the right to go into federal court with the belief appointed for life, not subject to political pressures, it'd be more fair. That's why when I sue State Farm out of Illinois, they have the right to put it into federal
Foreign
court.
entity meaning outside the state of Texas.
Exactly, any foreign entity.
Any of them based in Texas now?
Some of them
major
have
players.
Lloyd's that still is considered a Texas entity.
But most of these cases are folks
Most
that
of
are
them, I mean,
multinationals.
80+%.
They're based in
will go to
Delaware
federal court.
or somewhere?
Most of them are based out of Illinois or Connecticut or New York. On the other hand, if it's two Texans fighting each other, me versus the local adjuster, we can trust the Texas courts to sort that out, especially when it's a Texas law. And so that's what decides it. I've got a right, I've actually got a constitutional right to have my claim against the guy who cheated me heard. It's a right to a trial by jury. And you can't really say, we're taking away your trial by jury as to this guy because we think you've got a good enough one as to the foreign insurance company. That's just never been the law.
Now that's interesting, and that that's why these hearings are important. It helped me sort of flesh this out. So whoever did the drafting, we haven't had a whole line of adjusters in here, coming out of the First Presbyterian Church out of McAllen. So although it's under the guise of helping the adjusters, is really, I think, getting at this forum issue. Now, Mark, in your previous life, when I first met you, I think you were OPUC, Office of Public Insurance Counsel, right?
Yes.
Back many years ago. I mean, is it fair to say, for members of this committee, we don't have, on the state level, we don't have a lot of oversight over insurance companies anyway. I mean, I don't want to separate the issue, all this prior approval. There's very little control we have over their rates, most of what they do anyway.
That's true.
And this bill would apply to health insurance and everything. Health insurance is where we have the least regulation, right?
And business liability insurance, all of it.
And I just want to say, Senator Taylor, that's why this is so important, and this unintended consequence on your part. I think whoever did the bill knew what they were doing and intended to do it.
Thank you, Senator Ellis. Senator Watson?
Yes, and I apologize, I stepped out a minute. If this got brought up, just tell me and I'll shut up, maybe. First, let me talk about I want to ask you a question about federal court, because I think it's important for those that don't participate in the court system to know First of all, right now in the state of Texas, and Mr. Kincaid, you may not know, but maybe you do, how many federal district benches do we have that are open?
I think it's about a dozen.
I thought I was going to say 9, and I may be wrong about that. But what that means is we don't have a full complement of the federal courts that we might need with those kinds of. The other thing is a comment got made that I think is accurate, and I want to underline the point about in many of those cases they're swamped with criminal trials, and those trials constitutionally. You have the right to a quick trial. They end up taking precedence over the case, civil cases, right?
That's correct.
So what happens then is if you have a dispute, even if the insurance company owes money to someone, they get to keep that money as long as that case ends up being delayed. Is that right?
That's true.
In that, along those lines, under current law, I don't know the answer to this, but how many times does a claimant have to give the insurance company an opportunity to do the right thing before you can sue?
There are about half a dozen chances to do the right thing before you can sue the insurance company or before you can continue the suit. The careful balancing of this law has put in a lot of what I call safety valves, but it's chances for the insurance company to get it right and avoid a lawsuit. And in the frivolous cases...
Give an example of that, because if you say that there's a half dozen times that there's an opportunity to them to cure or to fix or to do what is right, what's an example of that? Because I think it becomes important as we talk about, as we talk about whether the insurance company gets mistreated in this situation.
The insurance company's got 3 strikes before you can sue them. The first one is they've got a statutory duty to come out and conduct a reasonable investigation and promptly pay the amount. If they simply do what the law and the policy require, there is no lawsuit. People don't sue over adequately paid claims. So they could win by getting it right. The second thing is if we find ourselves in disagreement on the claim, I'm not a lawyer, let's say I'm just a claimant, they've got the right to invoke appraisal. All that means is my estimator goes in, their estimator goes in, they get a neutral umpire, and the umpire says who's right. If they pay that award at that point, it's over. There's not anything else to litigate on that part of the claim. If we still find ourselves in disagreement and the client comes and gets a lawyer, I have to file a notice 60 days out before suit.
You as the lawyer.
As the lawyer on their behalf, stating the specific details of the complaint, exactly how much the plaintiff is claiming is still owed, and how much in attorney's fees. And that's very important because if the insurance company agrees, if that's a reasonable number and they agree, and they say yes, there is no lawsuit. If they disagree, they have the right under the statute to make the offer they do think is reasonable. Going forward, if the plaintiff doesn't recover substantially more than that offer, the plaintiff is barred from any more recovery. So the insurance company is protected from the unreasonable refusal to take an offer. They're given that same chance 2 more times during the pendency of the lawsuit, within a certain amount of time after suit's filed, but also after mediation. They can make the same offer again. And all they have to do to protect themselves is make an offer that is equal to what the fact finder ultimately decides should have been paid.
So what you're saying is there's 3 situations where if the insurance company makes an offer and it's refused, and as the plaintiff has the right to do, the plaintiff refuses that offer, but the ultimate fact finder finds that the offer was greater than or equal to what the insurance company offered, the plaintiff can't get any more than that.
That's right. And it cuts off your attorney's fees because there shouldn't have been any more attorney's fees. You should have taken the offer.
Thank you, Mr. Chairman.
Thank you, Senator Watson. Any other questions of this panel? If not, thank you all for being here. Appreciate your time.